Welcome back, everyone. My name is Judy Areen, and on behalf of AALS, the ABA, and LSAC, I'm very pleased to welcome you to the second panel of the conference. All told, there will be 3 additional panels today, all focused on the presidency, and particularly on appropriate limits on the presidency. It was inspired by the model used by Bob Bauer and Jack Goldsmith of identifying particular issues that need legislative or regulatory solutions. In preparing for the panel this morning, I spent some time looking at recent writing on the history of the presidency. I thought it might provide some useful context for today's discussion. Stanford historian Jack Rakoff noted in an essay last year that of all the institutions that the framers of the Constitution created, the most novel was the presidency. He explained that the value of an independent judiciary was well understood by the 18th century, as was the idea of protecting the privileges of the legislature. But creating a national executive was a, quote, truly novel and radical challenge because there was no precedent available. The framers knew they did not want a monarchy nor a ministerial government like the one that had developed in Britain. For a few weeks, they discussed having Congress select a president for a single 7-year term. How would that have turned out? In the end, they settled on the Electoral College with ties to be broken by the House rather than the Senate, so the president would not be too controlled by the Senate. The text of the written Constitution confirms that the framers were mostly concerned with Congress. Article 1 on Congress thus has 51 paragraphs. Article 2 on the President, by contrast, has only 13 paragraphs. Of those, 8 are about electing the president, only 4 about the powers of the president, and 1 on impeachment. The presidency itself has, of course, evolved over the 230 years since it was first invented. In the 20th century in particular, it grew more powerful because Congress simply could not respond quickly enough when serious threats to our national security arose. So whatever limits on the presidency are proposed, particularly any limits on the president's emergency powers or questions, the question is whether the limits might endanger our national security. So with that in mind, we've assembled a very talented panel to take on the questions for this panel. In order, let's see if we can get our panelists up here. I'm happy to introduce them. We will be hearing first from Kathleen Clark, who's professor of law at Washington University, St. Louis. Then Anne Joseph O'Connell, who's the Adelbert Sweet Professor of Law at Stanford. W. Neil Eggleston, a partner at Kirkland and Ellis, who also teaches at Harvard Law School and served as White House counsel from 2014 to 2017. And Jide Nzelibe, who's the Benjamin Mazer Summer Research Professor of Law at Northwestern. Kathleen, I'd like to turn things over to you this morning. I understand you're going to be speaking about tax disclosure, among other things. Kathleen.
Yes, thank you so much. I want to thank the AALS for inviting me to participate in this important conference, and also thank Jack Goldsmith and Bob Bauer for their terrific book. I am going to make the case for 2 transparency reforms related to the president's taxes and put those reforms in the context of a bit of history. So I believe that Congress should require presidents to disclose their tax returns and require the IRS to disclose its audit of those returns. These disclosures would be a way to mitigate a conflict of interest faced by IRS officials who review and audit the president's tax returns. First, a bit of history. During President Nixon's first term in office from 1969 to 1972, he paid a surprisingly low average tax rate of about 7% on more than $1 million in income that he received during that period. His tax returns for those years contained some highly questionable deductions that would likely have triggered an audit for an ordinary taxpayer, including a charitable deduction of more than $500,000 for donating his vice presidential papers. In processing Nixon's tax returns, the IRS did not initially raise any questions about that or any of his other deductions. In June of 1973, by happenstance, the public learned that President Nixon had claimed this large charitable deduction. The gift was revealed during a deposition in a lawsuit related to Watergate, and a Washington Post journalist wrote a series of articles about it. Later that year, a newspaper published information leaked by an IRS employee that Nixon had paid less than $900 in taxes in 1970 and 1971, even though he had more than $200,000 in an income each of those years. It was only after this leak that the IRS opened a second review of Nixon's tax returns. And on that second go round, the IRS rejected Nixon's claimed deductions, requiring him to pay more than $400,000 in back taxes. Now, tax experts had argued that Nixon's claimed deductions were not legal. So why did the IRS initially permit those improper deductions? At the time, one tax expert explained that IRS employees, IRS agents, and their superiors would be extremely reluctant to audit the tax returns of the president as if he were an ordinary taxpayer. In other words, IRS officials face a conflict of interest. On the one hand, the employees handling the president's tax returns have a duty to treat the president the same way they would treat any ordinary taxpayer. On the other hand, these employees may feel pressure to treat the president more favorably than they would an ordinary taxpayer. The conflict stems from the very structure of our government. The IRS is part of the executive branch. The president is the head of that branch. The IRS employees are in effect reviewing their boss's tax returns. Now, we can't entirely remove that conflict of interest faced by IRS employees because it's inherent in the structure of government. But Congress could mitigate that conflict by increasing transparency. If we required public disclosure of the president's tax returns and public disclosure of the IRS's audit of those returns, the IRS would be publicly accountable for the way it handles this conflict of interest. I think that the Nixon tax episode is sort of a useful example of the power of transparency in mitigating, although not removing, the conflict of interest here. Anyway, I'm going to stop there. I look forward to the presentations from the other panelists and to the Q&A.
Thank you so much, Kathleen. And now let me invite Professor O'Connell. Anne?
Yes, thank you. Thank you for having me, and thanks to Bob Bauer and Jack Goldsmith for their wonderful book. If you could bring up the slides, that would be great. And advance to the next one. So as we all know, the aphorism that personnel is policy, there are a good number of Senate confirmed positions in the federal bureaucracy. The quadrennial plum book, which has a surprising number of errors, has about 1,200 of Senate confirmed positions. And as of last night, you can see how the new administration is doing, right? It's slow going. It's slow on the White House side, and it's slow on the Senate side. If you could advance to the next slide, please. Now, because of the slowness and because of various emergencies, we've had various stopgap measures for political appointments in federal agencies since the start of the country. The first Vacancies Act was in 1792. We currently operate under the Federal Vacancies Reform Act of 1998. And it basically allows for 3 pools of officials to serve in an acting capacity in a certain subset of these 1,200 Senate confirmed positions. So that subset, the covered set of the Vacancies Act, are basically all of the cabinet departments and single-headed executive agencies like the Environmental Protection Agency, the independent regulatory commissions and boards, like the Merit System Protections Board, which currently lacks a quorum and has for several years, those commissions and boards are typically not covered by the Vacancies Act. So it's the first assistant to the Senate confirmed position that is the default acting official. So for a cabinet secretary, that would be the deputy secretary. For an inspector general, that's the principal deputy inspector general. That's the default acting official under the Act. But the Vacancies Act of 1998 also allows the president and the president alone to choose one of 2 alternatives to that default acting official. First, the president can choose someone who's been Senate confirmed to some other position, doesn't even have to be in the same agency, or the president can choose someone within the agency who's sufficiently senior, someone who's paid at the GS-15 level or higher and has served at least 90 days in the year preceding the vacancy. Next slide, please. There are also some time limits about acting service. You get 210 days normally without a nomination. You get an additional 90 days when a new administration comes in. The nominations make it quite complex in terms of the time limits that are permitted. And the idea is that you have to be drawn from one of these 3 permitted pools, and you have to serve within the time limits. And if you don't, the GAO may issue a violation letter, as it did earlier in March of this year under the Biden administration, in addition to the violation letters, there is the potential for actions taken by improperly serving acting officials to be struck down. Next slide, please. So I compiled a database of confirmed recess and acting officials at the cabinet secretary level from the start of the Reagan administration through the 3rd year of the Trump administration. Information is quite hard to find about the acting secretaries. And you can see that President Trump, through his first 3 years of office, had more acting cabinet secretaries than any of the 5 preceding administrations had in their entire administrations. Now, in parentheses are acting secretaries that served at least 10 days. So you can see when you actually compile not just the number, but how long they served, that through the 3rd year of President Trump's administration, acting cabinet secretaries served for about 10% of the days, which was a big increase from the preceding 2 administrations. Next slide, please. So I also compiled data on 3 positions at the EPA and also for the head of the Federal Aviation Administration, and you can see the breakdown there. And you can see that while what is true for cabinet secretaries as well, while all recent administrations have relied on acting officials, that the Trump administration used them more extensively, right? So in terms of the EPA administrator, for example, about a quarter of the time in President Trump's first 3 years, there was an acting EPA administrator as opposed to a confirmed administrator. And you can see that it was only about 6% in President Obama's administration and about 8% in President George W. Bush's administration. In parentheses, under the EPA administrator, that's the percentage of days in terms of the deputy administrator being an acting. And then the FAA administrator, about half of President Trump's first 3 years, we had an acting FAA administrator. This included during the 737 MAX crisis, but we also see pretty high vacancy rates and use of acting administrators at the FAA under President Obama and President George W. Bush. Next slide, please. Just to get one more sense of the numbers, You can do a snapshot. So as of April 15th, 2019, some wonderful law students at Stanford Law School and I tracked down kind of what was happening in 301 Senate confirmed positions across 15 cabinet departments. And in this one kind of snapshot of time, in 65% of the slots, there was a Senate confirmed appointee. In 13% of the slots, there was an acting official. And this is what I want to stress. What's really interesting is that the time limits for the Vacancies Act had run out for many of these positions, and there had never been a nomination. So 22% of these 301 positions had neither a confirmed official nor an acting official. And now presumably what was happening is that the non-exclusive functions of those jobs had been delegated down. Next slide, please. So there are a variety of issues, legal issues, that arise when presidents turn to acting officials as opposed to the traditional appointments process. Some of these issues span across administrations, and some of these issues were special to the Trump administration. So I'm just going to flag a few very quickly. So issue number one is a constitutional issue. Can someone who's not been confirmed to a particular agency position, can that person be used as an acting official in the very highest positions, principal offices under the Appointments Clause? And we saw a lot of controversy surrounding this in November 2018 after Jeff Sessions was pushed out by President Trump. And instead of relying on the Attorney General Succession Act and a confirmed Deputy AG, Rod Rosenstein, President Trump turned instead to that third category, the Vacancies Act, and chose a senior agency official, that being Matthew Whitaker, who had not been Senate confirmed to any position in the Justice Department in the Trump administration. But we've also seen this issue arise at the start of President Biden's administration. So the Senate didn't confirm a single cabinet secretary nominee at the very start of Biden's administration. He started with 15 acting secretaries, 13 of whom had not been confirmed to any position. So the case law on this, there was a lot of litigation over Whitaker. All of the lower courts sided with President Trump, relying on an 1898 case called Eaton, which seemed to suggest that someone serving temporarily in a principal office was an inferior officer and not a principal officer. But I think given the current composition of the Supreme Court, not clear whether that ruling would stand. Next slide, please. Issue number two is a statutory issue. What happens if there's a statute that's specific to the agency about succession provisions? So in President Trump's first year, the day after Thanksgiving, I'm trying to relax, but a whole controversy surrounding the CFPB blows up. And given my Vacancies Act obsessions, I get drawn in the holiday season. So Richard Cordray, as the confirmed director of the CFPB, resigns. On the way out the door. He names Leandra English as deputy director. Under Dodd-Frank, the deputy director shall serve as the acting director when the director is absent or unavailable. So Leandra English becomes the acting director of the CFPB, but then the White House, just several hours later, turns to the Vacancies Act and names Mick Mulvaney, who Senate confirmed to another agency as head of OMB, to be acting director. They both turn up to work claiming that they are each the valid acting director. And this comes down to a statutory question about whether the Vacancies Act is still available for the White House to use in the face of a specific agency succession provision. Now here, the lower court also sided with the Trump administration, and also with regard to the Whitaker litigation, there was the same sort of statutory issue, and all of those lower courts also sided with the Trump administration, saying that the Vacancies Act was still available, but there's still some ambiguity there. Next slide, please. A third issue is also statutory. What happens when the president fires someone? Can the president then turn to the Vacancies Act? So President Trump pushes out David Shulkin as Secretary of the Veterans Affairs Administration. And the question is, can President Trump turn to the Vacancies Act and name Robert Wilkie, who's a Senate confirmed official at the Defense Department, not the person under the agency succession provision, to be the acting VA secretary. That's what the Trump administration does. The question is whether the Vacancies Act, which allows, right, for an acting official when the previous officer dies, resigns, or is otherwise unable to perform the functions and duties of the office, does that last phrase cover firings? We have litigation here too. A bunch of veterans sued. They voluntarily dismissed their case before that litigation was resolved. Next slide, please. And then, although there are also other issues, this is the final one that I'll flag, is can you name a first assistant, that default acting official, after a vacancy occurs? The Office of Legal Counsel initially said no. Several years later, OLC changed its mind and said yes. This arose with regard to Ken Cuccinelli. The Trump administration, after learning that Senate Republicans would not confirm Ken Cuccinelli to be the next Secretary of Homeland Security after President Trump had pushed out Kirstjen Nielsen in April of 2019, the Trump administration gets Ken Cuccinelli placed in a new first assistant position. They create a new principal deputy director position at the United States Citizen and Immigration Services, which is a sub-agency of the Department of Homeland Security. And they do this after there is a vacancy in terms of the director of that agency. So there's litigation here. Here's litigation that the Trump administration lost. Now, interestingly, Randy Moss, who was the district court judge, who had been head of the Office of Legal Counsel, which had given all this guidance on the 1998 Vacancies Act, Judge Moss said that this creation of a new first assistant position was invalid. Interestingly, Judge Moss did not decide the statutory question about whether first assistants can be named after the vacancy, but rather said that this position was not a valid first assistant position. Next slide, please. So what to do? Well, earlier this week, Representative Katie Porter reintroduced legislation, the Accountability for Acting Officials Act, which I've endorsed, which would do a number of things. On the right, those in black are the things that are covered by the Accountability for Acting Officials Act, and the blue are modifications or additions that I would make. So several things that this legislation would do. Number one, it would clarify a bunch of ambiguities, right? Number one, it would specify that if there's an agency succession provision that is non-discretionary, as in the case of the CFPB, that specific agency succession provision would have to govern. The White House would not be able to turn to the Vacancies Act. Two, in terms of clarifying ambiguities, it would say that the Vacancies Act does apply to presidential removals. Third, with regard to first assistants, the proposed legislation would not allow the naming of first assistants after a vacancy. Now, I would like to modify that. Bob Bauer and Jack Goldsmith endorsed this in chapter 13 of their wonderful book. And this modification would allow post-vacancy first assistants in the first 6 months of an administration, and also if the first assistant dies or falls ill. In addition to clarifying ambiguities, reform would include cutting the time limits for principal offices. So right now you can serve an incredibly long time as an acting cabinet secretary under the Vacancies Act. Third, reforms would include increasing experience mandates, increasing the number of days someone senior in the agency would have to serve before being able to serve in an acting capacity from 90 days to a year. The legislation would also restrict acting IGs to non-political staff in the IG's office. And then finally, there's actually a reform I favor that is less restrictive, right? All of these proposed reforms are more restrictive on the White House. But one reform I favor that would be less restrictive is to give more freedom for those who are nominated to these vacant positions to continue serving in an acting capacity. After 2017, a Supreme Court case called SW General, it's very hard to serve both. There are some exceptions. It's very hard to serve both as the nominee and the acting official. And I would favor allowing someone to continue serving while their nomination is pending if they've been confirmed to another job. So they've already kind of gone through one round. This would have prevented Mark Esper, for example, in the Trump administration, who had been confirmed as Secretary of the Army. When his nomination was pending to be Defense Secretary, he actually had to step down and the Senate had to rush through the confirmation proceedings because of this detail of the Vacancies Act as interpreted by the Supreme Court in 2017. Next slide, please. Now, all of this reform, though, ignores a huge elephant in the room. If acting officials are a workaround to the traditional appointment system, well, delegations of authority are a workaround to acting officials. So when time limits run out nowadays with the Vacancies Act, what typically happens is that the non-exclusive functions, and there's very little that's exclusive of Senate confirmed positions, get delegated downward. And so you can do a lot of reform on the acting side, but if you don't think about delegations, everything's just going to move over to the delegation. So when you see this in Republican and Democratic administrations, especially later on in the terms when the time limits have run out, go to the leadership page and you'll see so-and-so senior official performing the functions of, and that means they can't carry the acting title, but they're essentially doing the same thing. All right, last slide, please. So there's a lot of talk, including this week, about the need to cut Senate confirmed positions. And I'm someone who believes in that we should cut the number of Senate confirmed positions. But the reality, the political reality, is that it rarely happens. And maybe we should start to think about actings actually functioning as a way of cutting a Senate confirmation. But we also want to make sure through various legislative reforms, we want to prevent certain abuses, right? We want the government to function. And because we have a dysfunctional appointments process on the nomination and on the confirmation side, we want to have acting officials and we want to have delegations of authority in the gaps in the traditional appointments process so that many important tasks can be carried out. But we need to balance this against the important role of Senate confirmation and to prevent certain misuses of the Vacancies Act. Thank you. I look forward to your questions.
Thank you, Anne. You took us through complex territory and made it seem understandable. Thank you. Neil Eggleston. Neil.
There we go. Got myself unmuted. So thank you, Judy. And let me just also join others in thanking AALS and the other sponsors for inviting me to this important event. And I also really want to thank Jack and Bob for the terrific book that they did. I was 2 White House counsels after Bob Bauer, and I have 2 thoughts. I've periodically told him while I was White House counsel that most days I was pleased that he had recommended me for the job, and there were days when I was cursing him. So I think that's probably pretty typical. The other thing I can't understand is how Bob Bauer, who was heavily involved in the Biden campaign, was able to write this book. And I think I'm busy, and I can't imagine how he could have spent this much time really writing such a terrific book. And finally, I just want to thank AALS and the other sponsors for putting on this conference. It is quite important, and I see there are a lot of people watching, and I commend all of you for participating and for putting it on. I'm going to focus on the book and some of the issues in the book. I watched their hour before this panel went, and I have some thoughts about some of that. I think many of their ideas on ethics reforms are really quite thoughtful and would be quite effective if they could get passed. As you know, and this was discussed in that panel, some number of them are included within H.R. 1, which has been passed by the House and is currently under consideration by the Senate. It is part of the huge bill, as I think Bob mentioned, that also includes changes to the voting system. I have to tell you, and maybe it's because I've been in Washington too long, but I'm skeptical of changes that have to go through Congress. Since particularly for the last several years, it's pretty much of a dysfunctional institution. It's become, if anything, even more partisan, and I'm even more concerned, if anything, that a number of these ethics reforms and the voting reforms will be seen as a repudiation of Trump or a repudiation of the Republican Party, and I don't see the Republicans signing on to this. I hope I'm wrong. I hope Jack and Bob are right and that I'm wrong, but I'm skeptical that we're going to see sufficient number of Republican votes to get beyond a filibuster-proof majority. So I'm a little skeptical of whether those are realistic. That's a realistic path or not. There's one statutory recommendation, maybe two, that I pretty much disagree with from Jack and Bob. And in that sense, I kind of wish they wouldn't be raising the issue, which is I really disagree with them on the notion that the obstruction statute and the bribery statute need clarification by Congress. What they say is that the statute needs clarification because of what's called the plain statement rule. And the plain statement rule basically says that Congress should be deemed sort of not to have intended a statute to apply to the presidency unless that's explicit. The big case, I think, is called Franklin, is a FOIA case. And the Supreme Court said that you shouldn't presume Congress intended FOIA to apply to the office of the president if it wasn't explicit. I think that's very different than an obstruction of justice statute that carries with it a corrupt intent requirement. In fact, to me, the flip side seems more logical, which is the likelihood that the Congress intended to exempt the president from a criminal statute that carries with it a corrupt intent requirement seems to me to be quite low. I have the same sense, frankly, and Bob and Jack talked about this in connection with whether the bribery statute needs to be amended to make it clear that the president cannot sell a pardon. It seems to me bribery is one of the provisions, if I'm remembering right, in the impeachment clause, and it seems to me pretty clear that the framers, that was among the kinds of conduct that a president could be sanctioned for. And so I really think neither one of those requires amendment in order to make a clarification. Having said that, I might, again, so there could be other constraints, the OLC opinion and various things, although a new LLC could always change the old OLC opinion. But in terms of the statute, I'm not convinced at all that they do not already cover presidential conduct. Having said that, I do actually agree. I'm probably close in some ways to the Goldsmith position, which is that I think the prosecution of a president for conduct while in office, his official conduct, is problematic and really would have to be quite overwhelming evidence in order to proceed for the reasons that Jack talked about. I feel completely different, though, about possible prosecution for if President Trump has committed tax fraud, particularly before he was president, if he's committed campaign finance fraud. I think that we need to be careful about prosecuting official functions. On the other hand, I don't think the fact that someone gets elected to be president gives them immunity from non-presidential conduct. And I have a different view really about that. But let me, I think that the mostly what I want to talk about in this, the time I have left, is how Trump was able to get away with sort of pervasive norm busting throughout his 4 years with really very little consequence. Most of the norms that Trump ignored have been in place in one way or the other for decades. And I think of this as much of these norms, and the last time we had real sort of ethics reform was in the post-Watergate era. And I think presidents have sort of been inclined not to be engaged in norm busting because of President Nixon. He was the last great norm buster, and life did not turn out too well for him. And I think that has caused presidents since that time to be much more attentive to the way they talked and thought about various different issues and tried to make it clearer that whatever they were doing, they wanted to put it in the patina of working on behalf of the American public and not on behalf of their own sort of personal benefit. Jack Goldsmith has a great line that he uttered or wrote, or I can't remember where I saw it, early in the Trump presidency, which is that President Trump was the first president, perhaps since Nixon, who really told you exactly what he was thinking. I mean, he would just say, I'm busting this norm, and because it benefits me to bust the norm. And in some ways, Jack, I think, thought that was refreshing. I would have preferred different conduct and less candor. Maybe it would be the way I would have gone about it. But I do think that President Nixon was a constraint on subsequent presidents until we got to President Trump. Norms obviously do not have the force of law. And so really we have to rely on other enforcement mechanisms because there's not typically a legal enforcement mechanism. That's why it's called a norm and not a law. President Obama, for whom I served, it was very important to him that we stay away from these types of ethical lapses. He did not want sort of his productive time and the office's productive time devoted to fighting about ethical lapses. He wanted to fight about policy. And so keeping sort of on the straight and narrow, which we largely did, no administration is perfect, but which we largely did, was important to him. It was people stayed on the straight and narrow because he made it so clear that he wanted to do that. But President Trump had a different sort of governing philosophy. Sort of fighting every day on every issue was the Trump governing philosophy. So the notion that he's fighting about all these sort of what President Obama would have considered petty issues and fighting with Rosie O'Donnell and all this would never really have occurred to President Obama. But the result was that President Trump was really unconcerned about norm violations. And I think to the contrary, he regarded them really as badges of honor. And I think his supporters largely had the same view. I don't know if people who are watching listen to the podcast Strict Scrutiny. I'm a very devoted listener to Strict Scrutiny, but they have the line as they're talking about sort of some conservative decisions, which I really like, and I think they may have put it on a T-shirt, which is stare decisis is for suckers. Well, I think to Trump and his supporters, you could have written, norms are for suckers, and so that's sort of the way they kind of thought about it. So finally, let me just talk about what are the enforcement mechanisms, if you will, for norm violation. I have the following list, and I'm going to talk about each of them pretty quickly. Congress, the media, inspectors general, courts, and ultimately voters. My view is, except for voters last fall, which obviously is the most important check, the typical enforcement mechanisms largely failed. Let me start with Congress and the media. When I talk about Congress, well, let me just start with them. I think they both suffered, two things. When I talk about Congress, I'm really talking about the Democratic side because the Republicans just were not going to criticize President Trump. But they both, the media and the Democrats in Congress, suffered from overload, which is there were just so many and they came so fast and they came every day that there were just too many for the media and Democrats in Congress to be able to focus on. As soon as they started off on one, a new one showed up, and there was never any ability to sort of get it into the public consciousness about what was happening. The norm violations, I think, and the complaints, if you will, became just background noise, and people, particularly as supporters, but I actually think people who were not as supporters sort of began to shrug their shoulders and say, he is who he is. Let's stop talking about it. This is just getting me exhausted. And President Trump benefited, I think, significantly from overload. He was able to perceive that his core supporters viewed the norm violations as part of the reason that they actually liked him. And the final thing is, I think that both the media and Congress did a particularly bad job of explaining why norm violations mattered. And that is, most of these norm violations are built around a principle that we want the president to operate to the benefit of the American people and not to his own personal benefit. And I think the reason that these norm violations were important got lost, and it turned out just to seem like an endless stream of complaints. Much way my kids probably thought about me when they were teenagers. It just sort of rolled off their backs and ultimately became ineffective. Let me go next to inspector generals. I regard the performance of nearly all the inspectors general as quite disappointing in the Trump administration. There are definitely some exceptions. The Ukraine matter started because Michael Atkinson, who was the inspector general for the intelligence community, took the position that the whistleblower complaint he got was covered by the statute. And as a result, he had an obligation to provide it to Congress. I think he actually ultimately didn't, but he informed Congress it existed, and as a result, it eventually got to Congress. And oddly, it was the reason he ultimately didn't is that OLC, the statute says specifically that the inspector general shall decide whether the whistleblower complaint shall be referred to Congress. OLC swooped in and said, actually, it's not his, interesting statute, nice words, but it's not actually his decision. It's our decision about whether it should be referred, because we get to interpret statutes and our interpretation is binding in the executive branch, and we're the ones who get to decide. I've not included OLC in my list because it's an executive branch agency, but I pretty well could. And for his efforts, if you all recall, Michael Atkinson was fired by President Trump. There's been some recent reporting that Inspector General at DHS did not want to do investigations that might touch on President Trump because he thought he might get fired. We're now learning of refusal in a number of different agencies to cooperate with IG investigations. Those refusals should have been reported to Congress and should have been reported to the American public at the time they took place. They shouldn't have been reported after President Trump left office. And I'm going to throw out a list, and you will all have a much better list. And I think these are all right. It's possible I'm going to complain about a report that didn't come out, and somebody's going to shoot up on the chat. Actually, Mr. Eggleston, it did come out. I don't think that's going to be true, but I could be wrong on this. So where is the Commerce IG report on how it came to be that Secretary Ross's testimony before Congress about the reason for a citizenship question was, in the words of Chief Justice Roberts, contrived? Chief Justice Roberts had 3 or 4 different descriptions of he was describing the rationale, not the testimony. It just happened to be that the testimony was under oath. But basically, Chief Justice Roberts concluded that explanation given both in Congress was false. And where is the Commerce IG report explaining to us how that came to be that a secretary gave false testimony in front of Congress? At the State Department, why did we not learn until Secretary Pompeo was gone that he and his wife had misused official resources at the department? At the Department of Justice, why don't we have a report yet on what happened in Lafayette Square when the square was ordered cleared in order for President Trump to have a photo op, if I remember right, holding the Bible upside down at the historic church across from Lafayette Square? At DHS, why don't we have reports yet on the diversion of money from military to a fence and whether the fence is in fact effective? We see these stories all the time. In the story in the last couple of weeks in the New York Times that the migrants are showing up at the fence with a big ladder and climbing over the fence. Frankly, a lot of people are saying, let's spend the money. We need border enforcement, but a big barrier is not the appropriate way to do it. As I say, you could all probably come up with better examples. These are things that I would have thought would have happened. And the last thing, having sort of been in now 2 administrations, Senator Grassley had already sort of portrayed himself as a big defender of inspector generals. I think he wrote one letter, as far as I know, protesting the firing of so many inspector generals and very little else. Let me cover the courts and then voters real quickly. Look, the courts had a whole series of issues. The most disappointing part to the courts to me really was the timing. I think that they did not treat these issues as issues that needed to be decided quickly. Those of you who follow the emoluments litigation, which was in the Fourth Circuit and various other circuits, I think there may have been one in the Second, I can't quite remember. But when the term ended, the courts are still fighting about standing, and they had gotten nowhere near the merits. They were still fighting about standing, and we were 4 years into the presidency, and it never really mattered to anybody, maybe but me. But the provision says the president can't take an emolument unless Congress first approves it. There's no he takes it and then it's approved after the fact. They have to approve it before he takes it. And yet still we had all these fights about standing and whether members had standing, and actually think the House in some ways dropped the ball and should have done it better. The McGahn case on subpoena power of Congress essentially took the entire 4 years. And then I think the Supreme Court essentially worked it such that there wouldn't be any action until after the election. Contrast that to what happened with the Watergate tapes case, which was decided by the Supreme Court. Others will remember better than I do, but 3-4 weeks before the case was decided. I think we never got a resolution on whether the House Ways and Means Committee could get President Trump's tax returns in the face of a statute that says it does on request and has no exception and has no role for Office of Legal Counsel in that determination. It seems to me that should have been a pretty easy case. So finally, let me just get to the voters. Obviously, Trump was eventually defeated at the polls. And it'll be just interesting to see, and I'm not a political scientist, and so I'm not going to make a prediction, but it'll be interesting to see whether the response to that by future presidents, assuming the next one is not President Trump, it will be a return to the let's stay away from this stuff. It didn't help Nixon, and it sure as hell didn't help President Trump, or whether there'll be a view that much of the way that President Trump ran his presidency actually turned out to be pretty effective, and he just barely lost. And obviously, to a lot of Republicans, he didn't actually lose. And so I think the impact, even in the face of a defeat at the polls by President Trump, it'll be super interesting to see what happens going forward. Anyway, thank you very much. I'll give my remainder to the last panelist.
Thank you so much, Neil. And let me call on Jade.
Hi, good morning. Can you all hear me?
Yes.
Okay. Thank you. So I am going to probably take off from where Neil left and build upon it, and maybe also respond to some of the stuff that I think Professor Clark mentioned earlier. And so my thesis, my primary thesis, is that if you're going to constrain presidential self-dealing of the nature that is proposed, I think in this really interesting and really compelling book written by the authors, and I'm going to focus on chapters 3 and 4, where they discuss conflict of interest in tax disclosures. If you are going to constrain, it is much better to do it through subterfuge and not directly. That is, the constraints that work the most are those where the constraints happen to be a side benefit, incidental side benefit, rather than the goal of the statute. And when you try to make it the direct goal of the statute, it's going to be both politically vulnerable for some of the reasons that Neil mentions, and also, I think, legally vulnerable, right? So what do I mean by both politically and legally vulnerable? I mean, Neil brings up the issue, and others have brought this up, of whether this thing all of these proposals could get through a polarized Congress, and especially how Republicans will read it. Is this an insult on Trump, or is this an insult on the legacy? Is this an insult on the base? And so you have that aspect. But there's also the politicization of how it will be used if it's understood that this is a statement of worry about the presidential motivations, right? So then the question is, well, what are the kinds of constraints that are not directly dealing with self-dealing that may actually help mitigate self-dealing? And actually, you discuss one of them in passing in the book, which I think could be developed further, which is on page 67. You talk about mandatory Secret Service protection, right? Which is, when you think about what mandatory Secret Service protection is, it has very little to do with trying to constrain presidential corruption. It is to protect the president. But I think one of its side benefits is that it makes presidential self-dealing somewhat difficult. It's very hard to engage in a lot of self-dealing if you can't be alone with a lot of people, right? If you can't go and visit a hotel down the street and have a secret meeting because the Secret Service is going to follow you around. If, for example, your phone cannot have multiple functions and you can't talk to multiple people because they've given you a toddler phone or something like that. All of this ostensibly to protect the president. But one of the side effects of this is that it puts him into what you would consider to be, or her, into a goldfish bowl where everybody sees what they're doing because they're trying to be protected. And when you're trying to be protected, it's more difficult to engage in what I call these aside self-dealing attractions. Now, having said that, the problem you face is that when you directly try to constrain the president, let's say you even get it through Congress, right? And you make it through and you're trying to exercise it, it may be vulnerable in the courts because the Supreme Court may decide a statute that directly impugns the president, where when they have to render the decision, they have to say that the president acted badly, right? Maybe something they'll be reluctant to do because they may believe it leads to separation of powers problems. They just may feel if we can constrain the president through some other justification, we may say you should vet it through 6 different groups because of epistemic reasons. You'll be more informed. But vetting it through 6 different groups means there's less chance. Like if you say, go to the pardon attorney. Why are you going to the pardon attorney? Excuses that so that you'll be better informed. But if you go through the pardon attorney, it makes it less likely that you're going to engage in corruption. But you have an excuse that you're trying to make the president better informed rather than impugning the president's integrity. So these kinds of mechanisms where courts can justify their decisions based upon the fact that they're not trying to impugn the president's integrity suggests that indirect statutes are more likely going to be effective, and those that directly impugn the president are more likely to be problematic. Now, I just wanted to say one thing in response to what Neil brought up, and another what Professor Clark brought up, which is the idea, let's take the idea of tax disclosures. I think there's a sense that this is a kind of direct constraint, because one of the things that it does is that it exposes any shenanigans that you may be engaging in, financial shenanigans. And so the requirement that you file it, right, if it's mandated, if it goes from a norm to a mandatory disclosure, the idea is that it's just going to be benign. And my suspicion is that it may have asymmetric effects. Who will like mandatory disclosures? I think career politicians stand to benefit. Let me put it this way. Mandatory tax disclosures, in my opinion, may tend to make career politicians look much better than they are. And then it may tend to make wealthy outside politicians look much worse than they are. And for that reason, right, it may have an asymmetric effect. Let me give you a reason why I say this. In past 20 years, if you look at the kinds of people who have opposed these kinds of disclosures, pushback, Mitt Romney, before he ran for president, was very leery of disclosing his taxes, right? Who else was leery of disclosing? I go through the list. During the time he ran for mayor, Bloomberg, right? Pushback, only disclosed, had to redact it. Who were some presidential candidates who came up who kind of bucked the norm and didn't disclose? Ross Perot, Steve Forbes, who, when she was running for governor of California, decided, what do these people have in common? They're not all unscrupulous people. Meg Whitman decided she wasn't to disclose. They are usually very wealthy outsiders who are trying to throw their hat in the ring. And they're opposing it not because I think they're particularly unscrupulous people, but because they're particularly wealthy people, right? And also they're outsiders. Now, some may say, great, let's put that cost on them. Let them have to bear that extra cost. But no, that in our political system, if you want politicians to come outside what I would call the normal party career stretch, most of the time, the people who do that are actually going to be billionaires or possibly previous military generals who were heroes in a war, something like that. But otherwise, right, it means that you're giving the edge to politicians. The individual who decided when they were nominated or when they were going to be U.S. attorney, that this is the channel that they're going to take to the presidency. So what can they do? They can do the same thing that wealthy people do when they try to get their kids into schools. They can customize their tax disclosures to make themselves look much better than they do. What do? 20 years ago, they start the donations to charities. They double their donations to charities. They make themselves look particularly appealing because they guesstimate in 15, 16 years from now, they're going to throw their hat into the ring. They can do all kinds of things, try to monitor the kinds of people they hire, make sure that they're not people who are unauthorized, doing all those things that some billionaire who decided to throw their hat in the last ring may not be in a position to do as much, and partly because the way they deal with charity may be the different ways, may be completely different from the way ordinary average people deal with charity. They may decide to accumulate and give a huge donation later. So they have all kinds of things. The other thing is that their tax disclosures may make them vulnerable to their competitors, which is you can assume that whomever Bloomberg or whoever, Meg Whitman, whenever they're done with their politics, they want to go back to doing the kind of stuff they used to do before. And maybe one of their concerns is that they've disclosed a lot of sensitive information to business rivals, which they don't want to do. A lot of career politicians don't face that constraint. Anyway, I'm just trying to suggest is that we have to be transparent also that these things have a cost. Maybe in the end, the tax disclosures have much more benefits in terms of constraining bad behavior than in terms of screening out billionaires that we may want to run for office, who may think may be great candidates, but we should acknowledge that. The last thing I wanted to suggest just to throw out here is Neil brings up the issue of norm busting. And we have to be very sensitive that norm busting, when you're in a democracy, may not always appear to be a bad thing or a good thing, even when it looks like it's self-interested norm busting, right? So what do I mean by this? Usually when you have folks, let's say, for example, in a populist type election, where there's a populist candidate who's trying to undo, let's say, a party or administration or kind of leader who's been in office for the past 20 years. One of the things they may signal is that we're outside the box. We don't fit the bill that they fit in. And one of the things they may say is, I'm going to bust the constraints. And another thing they may say, those constraints that exist, both formal and informal, are meant to protect the elite. That's usually what they'll say. These are all things, all these mannerisms, all those parties, all those tax disclosures, all those things are really scurrilous things they use to protect elite interests. I'm going to come in and I'm going to smash through all of them because I'm on your side. If that's transparent, and if the public buys it, then so be it. We have norm busting. Who are the norm busters? You know, you could say Trump is one of them. You could say Duterte in the Philippines is one of them. You can say Charles de Gaulle of France was one of them. But they're not people who are caught from obey the norms and stay on the narrow path kind of people. And a lot of voters may say that's what we want. And so we have to be very, very, what I would say, careful about sometimes the moves and constraints and things that we want. How many times are we trying to preserve the democratic process, and how many times are these moves somewhat anti-democratic, right? If we think that the public actually, or the voters, or this person's primary supporters actually endorse the idea of the norm busting. So I just throw it out there. I mean, I do not have strong commitments one way or the other in this issue. I just wanted to throw out there that there's another story on the side that has to be told. And I'll leave it at that. Thank you.
Thank you, Jide. And indeed, let me extend my thanks to Kathleen and Anne and Neil. You had so much to say as individual panelists. We are through our time as a panel, but I think it will leave our listeners with really good points to review especially when we tie it back to the first panel of the day, where the message from Bob and Jack seemed to be, you've got a limited window when there might be bipartisan support for some of the reforms. Now, whether those reforms will meet today's suggestion that you have to be clever about the reform and have a clear justification that isn't just taking down a president, and the importance of understanding ultimately what you can get through Congress will also turn on how segments of the population feel about it. So you've reminded us, even if there's a will for some of these reforms, and a good case has been made by many of you, and certainly Bob and Jack, that doesn't mean it's going to be easy to do. So let me thank all of you and tell our audience that we're actually going to take a break. We know people have personal lives to live in this Zoom world. So we're not going to gather again until 2 p.m. Eastern. And I look forward to seeing you all back here for our terrific third panel, which will be on independence of the Department of Justice. Thank you very much.